estates or collections of assets can differ immensely in both size and complexity. While one person's estate may simply include a few bank accounts, another may hold title to various properties, stocks, businesses, and more. A small estate affidavit is a written document that allows the rightful heirs to inherit a deceased person's estate without going through the long and complicated probate process as is typically required. Each state has its own laws and requirements that determine what qualifies as a small estate and how it should be filed. In this video, we'll discuss how a small estate affidavit works, when you can use a small estate affidavit, and what steps you can take to file one. Before we start, don't forget to hit that subscribe button for more videos by eForms, the world's largest database of official legal documents. First, let's review how a small estate affidavit works. A small estate affidavit allows the estate to bypass the probate process, which involves going to court to figure out who gets what. When a small estate affidavit is filed by a rightful heir and no one objects to the small estate filing, the filing party will receive the assets and properties of the estate, as well as any debts owed. This process usually takes a fraction of the time it takes for a probate procedure to move through the court process. So when can you use a small estate affidavit? Each state sets its own monetary limit and the minimum number of days that you must wait after the death before filing the small estate affidavit. And while small estate affidavits are typically used when there is no will attached to the estate, some states allow it to be used with a will under certain circumstances. Since these requirements vary by state, it is highly recommended that you check out the laws around small estate affidavits in your own state. So say you've checked your state laws and you've found that you are eligible to use a small estate affidavit. What now? There are a few steps to make sure that your small estate affidavit is successfully filed. Wait for the state. Required time period. This can range from 15 to 60 days after death, depending on where you live. Calculate the estate's value. All assets and property that count as part of an estate under state law must be identified and valued. Make sure it falls under the state maximum requirement. Gather required documents. In addition to the death certificate, you must present the title of all properties owned by the decedent. Complete the small estate affidavit. It is highly recommended that you use the state-specific version to make sure that it will be accepted by the probate court clerk's office. Make sure to include an itemized list and all of the assets and property of the decedent. And when signing, the petitioner will be required to sign the form in front of a notary public, witnesses, or both, depending on the state. Contact family members and heirs. All heirs, family members, or anyone that could be considered entitled to the property must be made aware of the small estate filing. Therefore, the petitioner must contact them via certified mail with return receipt and keep the receipts as proof that the individuals have been notified. And lastly, file with the probate office. Attached to the small estate affidavit, the petitioner should have all of their documents together with the filing fee. The clerk will take between 5 to 15 days to process the filing. If accepted, the property and assets will be transferred shortly after. If you are in need of state-specific small estate affidavits or any other templates regarding estate planning, probate, and more, we have thousands of state-specific, ready-to-go templates available for you to download.